Welcome everyone for our webinar today. We're going to get started in about 2 minutes and we'll be back with you in a moment. Thank you. Okay, we're going to go ahead and get started. Good to see everyone back. As you might know, my name is Michael Ibrahim, and I am Program Manager with the Cultural Investment Portfolio here at the Mass Cultural Council. The CIP's focus is grants and services for nonprofit cultural organizations, and we are excited to present our final webinar in our legal series with the Arts and Business Council of Greater Boston, focusing on the legal considerations for remote work. Whether you're continuing it, doing a hybrid version of it, in some points, it's here to stay for a while. This workshop is part of our Recover, Rebuild, and Renewal series to help organizations come back from COVID-19. You may have already attended a few of our webinars so far. We've done 30 of them. And so we'll still be offering 2 every week until the end of June in areas of financial management, obviously legal issues, advocacy, management, and governance. Joining us back again are Luke Blackadar from the Arts and Business Council of Greater Boston and Danielle Germa-Letterman from Morgan, Brown & Joy. We're going to get started in just a moment, but a few ground rules. If you want to say hi in the chat with the organization that you're representing here today, it's just great for everybody to kind of see each other, at least in a webinar where you can't see everyone's face. We have automatic captioning for today. So automatic captions are provided on all Mass Cultural Council webinars and meetings. If you do need additional accommodations, just let us know when you register and we'd be happy to provide that. If this is distracting, you can always hide that using that closed caption options at the bottom of Zoom. We will have time for questions and answers, of course, on this topic. So feel free to use the Q&A function in the Q&A, and that's a great way for Danielle and Luke just to answer questions as we go along. Don't wait until the very end to ask a question. Just ask as we come along, and we're happy to do it. This session is being recorded and will be available on the Mass Cultural Council's YouTube channel probably tomorrow. So we'll email you that when this is available, but feel free to send it around to anybody that you think could benefit from this. I'm going to be posting some things in the chat as we go along today. So we'll keep the chat just for resources, and then we'll have Q&A just for the questions. This session is about an hour and a half, maybe a little less. We'll see how we are with the questions, and then we'll go from there. Without further ado, I'll turn it over to Luke and Danielle.
Thanks, Michael. Hey, everyone. I'm Luke Blackadar. I'm the director of the Volunteer Lawyers for the Arts, a program of the Arts and Business Council. And this conversation today really is a continuation of, I'd say, 2 themes at this point. One, like Michael said, this is the conclusion of our mini series on legal issues for nonprofits in light of COVID and the pandemic. We'd previously spoken about with Danielle employment basics. We spoke with Jill Havens about unemployment obligations. We've spoken about mergers, acquisitions, and kind of general risk management, risk mitigation, and risk assessment for nonprofits. And so this is a continue of that theme in terms of what are the legal considerations you, either as staff or a board member or some other type of organizational leadership should be thinking about from a nonprofit perspective. And then the other theme is kind of a continuation of the previous conversations that you would have had with Anita Morrison-Matra and Erin Johnson about, how to do work from home well, how to do it, managing your own health and well-being, and strategies for doing it, smart and setting up boundaries and things like that. So here we're kind of straddling those two topics. Obviously, we're going to talk about the nuts and bolts of some of these legal issues that are common to working remotely and having a remote workforce. But also a lot of it is going to relate to, how are we also strategizing about doing this right? So I'm so happy that Danielle is with us again, and she'll be chatting about this because she really is the expert on this area. So Danielle, I'll leave it to you.
Great, thank you, Luke. And thanks to the Mass Cultural Council and the Arts and Business Council of Greater Boston for having me here. I'm glad to be here again. My name's Danielle Jurema Letterman. I'm an attorney at the law firm of Morgan, Brown and Joy. I've been practicing law for over 8 years. I practice labor and employment law on the management side. So that means I counsel and represent employers in all aspects of their business, which includes everything from discrimination, sexual harassment, drafting employee handbooks, to dealing with wage and hour law and retaliation lawsuits. I've previously worked on the employee side as well, so I've really seen some of these issues firsthand from all angles. With much of the Massachusetts workforce, especially now, engaging in remote work, this is a really good opportunity to take time as employers to assess whether the systems you have in place or are thinking of putting in place really are working for your organization and your employees. And working from home while creating flexibility for both employers and employees, it does carry some legal risks and consequences. So we'll talk about those today. And of course, as with everything, it's further complicated by the present pandemic. So we'll talk about that a little too. So to begin, we'll start talking about working from home. I wanted to start with this agenda to just give everyone a sense of what we're hoping to cover today. These issues around working from home, some have been around for a while and are likely to stay relevant, especially given the present pandemic and ongoing concerns. And yet businesses are also still constantly changing the way they operate. And the pandemic has also brought about new concerns that we haven't necessarily seen before. So whether you've been dealing with work from home in your workplace for a long time, or it's something completely new to you that you're thinking of taking on, hopefully this session will give you an idea of some of the risks and how to proactively minimize them. So the goals for this session are to get an understanding of what the legal framework of remote working is in order to avoid any risk and pitfalls that can otherwise face your business. To have a sense of how the COVID-19 pandemic also impacts this, we'll be covering the hot topic of the day, which is COVID-19 vaccinations and whether and how employers should require them of their workforce. And we'll also be covering just some work from home best practices that'll deal with some common employer mistakes and how to avoid them. And finally, we'll cover returning to the workplace for those of you who might be contemplating an end or partial end to work from home, depending on improving results from the pandemic. And then we can also take questions at any point in time, and we should also have some time for questions at the end. So without further ado, we'll begin with some key legal considerations. There's a lot to consider with remote work, just like there is in your workplace when you're working every day at a work site. So there's going to be wage and hour implications. We're going to talk about expense reimbursements, how that should work, and policies to help guide you around that. Choice of law questions, because a lot of employees now working from home for the first time may no longer be working in the state that they were originally reporting to, or they might have moved in the pandemic because remote work is no longer tying them to one location. We're also going to talk about what reasonable accommodations look like and how employers should provide for them. We'll discuss workplace safety and how you're still expected to keep your workplace safe even when you have employees working remotely. And especially when it comes to remote work, we'll be talking about data security and employee privacy, as there's lots of little nuances and complications that come about when you're dealing with employees working outside of your fixed work site location. So that's some of the legal considerations we'll be covering today. So starting with wage and hour law. So you might remember some of this from our discussion in March when we were talking about employment law basics. But there's wage and hour implications that come about specifically in relation to remote work. But before we even really discuss those unique problems, let's just go over the basics again. So federal law and state law apply to most workplaces. The federal law is the Fair Labor Standards Act. Massachusetts has the Wage Act and overtime laws and minimum wage laws that apply to your workplace, regardless of whether you're working remotely or at a fixed work site. And typically when you're dealing with federal law and state law, or sometimes multiple state laws, depending on where you're located and where your employee is located, typically the law that's the most protective of the employees is the one that's going to control. So when you have a federal minimum wage and then a state minimum wage, which is higher than the federal minimum wage, you as the employer have to follow the state minimum wage, which is higher because that's what's more protective of employees. And the federal law usually sets the floor, and states often can go above and beyond those more minimum requirements. You'll also want to be considering your workforce and whether they're exempt or non-exempt. And when we're talking about exempt versus non-exempt, we're talking about entitlement to overtime. And there's a legal presumption that employees tend to be non-exempt, so entitled to overtime. And there's different tests and standards you need to meet in order to prove that an employee does not get overtime, so getting paid time and a half for hours worked over 40 in a given work week. State and federal law also both expressly require that you keep accurate time records of the hours that your employees are working. And this is where it gets very interesting with remote workers because keeping track of employees' time isn't as simple as it might have been if you had a specific work site and you could just punch in and punch out as you entered and left the facility. So when it comes to non-exempt employees, now those are the employees who are eligible for overtime. So non-exempt workers are typically paid only for the hours they worked, but they do need to be paid for all of the hours that they work, both under federal law and Massachusetts law. Now, remote work doesn't change those federal and state wage and hour laws, but you do want to make sure you're especially clear on the schedules and expectations that you have for your employees, especially with remote work, with regards to the hours you expect them to work, if they have unpaid lunch breaks or other breaks that they're going to take. You want to be very clear, preferably put those in writing so that you're being clear with your employees about what expectations you have for them. And that record keeping of the hours that they're working is legally required. So it is your responsibility as an employer to be keeping those records. You also might want to consider a policy that strictly prohibits off the clock work. We often recommend that even when we have employees reporting to a work site, sometimes requiring manager pre-approval of overtime. It's a good way to guide and explain to your employees when you want them working and when you don't want them working. And you really want to be able to keep track of all the time that they do work. It's your responsibility because you need to pay them for all the time they work. And it's good for you to communicate to employees how much work you want them to be doing and do not want them to be doing. And so again, so having overtime being approved by a manager in advance, making sure employees are aware of that policy, especially if it's consistent with what you were doing pre-pandemic, can be a very good way of ensuring that you're keeping track of employees' time and being clear with them about when they should be working and when they shouldn't be working. So with remote working, tracking the hours your employees work does tend to be a little bit more complicated. You might want to try incorporating something that you could have used sort of in a physical location, similarly now in an electronic form, whether via timesheets or some sort of time tracking software, if that's something that's really feasible and workable for your business. The key is really that you know exactly what hours your employees are working, so you're paying them accordingly, and you're not dealing with a claim from an employee or former employee down the line saying, oh, I was working these crazy hours and my employer knew about it because I was very productive and was clearly doing all of these things outside of business hours, but not getting paid for them, because then you're in Massachusetts, which is a very employee-friendly state, and we have the Wage Act, which means if an employee proves that they're owed wages that they weren't paid, they can get triple damages, so 3 times the amount that they're owed, plus attorney's fees, costs, interest. It can just get very, very expensive. So you really want to be clear that you're paying employees properly. You don't want to sort of monkey around with an employee's wages. You want to make sure that they're getting paid on time and for all of the time that they work. Also, for employees who might be entitled to unpaid meal breaks or other breaks during the course of their shifts, you want to make sure that those employees are still getting those breaks, or else that the employees are being paid for working through that time. So how you enforce that, you need to look at your business and assess what the best way to do that is, whether it's a do not disturb function or sort of a mandatory log in and log out shutdown time of their work computer or whatever equipment they're using for that time period, so that your timekeeping system is also showing that the employee is not working during that time, and that's why they're taking those unpaid breaks. You want to be very mindful about sort of off the clock tasks that can happen so easily in a remote working environment, such as reading and responding to emails during off hours, because all of that time can add up over the course of a week and then end up leading to overtime claims and claims for additional wages if employees are spending a lot of time doing that outside of your typical workday. So that's just a couple of things to consider when we're dealing with wage and hour law, and the sort of additional risks and caveats that come about when it comes to dealing with a remote working environment. And especially when an employee is working outside of their scheduled hours or excess hours, they are owed overtime. The law is pretty strict about that. If an employer knows or has reason to know that that work is being performed, the employee is entitled to it. It doesn't matter if it's prohibited or if the work wasn't specifically requested or authorized. The law really comes down pretty strong on the side of employees, so that they're going to get paid for their work because it's still benefiting the employer by them working those longer hours. So a key consideration when sort of thinking about all of these wage and hour implications is try to communicate your expectations clearly to your employees, especially when you're dealing with a remote working environment. Make sure that they know the hours that they should be on, the hours they should be off, how to track their time, and when and how to take breaks. That can all help minimize your risk in just dealing with and assessing these different wage and hour issues.
So we did get a question, Danielle.
Oh, great.
Should contractors be tracking their time as closely as you recommend for non-exempt employees?
So with independent contractors, first, I always have to say this, and you'll get sick of me saying this. In Massachusetts, almost every individual working for you is an employee. The presumption is that they're an employee. You have to meet some very specific prongs of a 3-part test in order to prove someone is an independent contractor and then should be paid like an independent contractor rather than an employee. So you want to keep that in mind, because if you later find out that you classified someone as a contractor and then they should have been classified as an employee, you might be on the hook for overtime obligations, minimum wage obligations as well. And all of that can come with those Wage Act damages, which makes you on the hook for a lot more. That being said, if you're paying your contractor on an hourly rate, you probably want to have a good sense, just from your own business sense, of how much time they're actually spending doing work so that you're paying them accordingly. You don't want to be overpaying your contractor if you're not really closely assessing the amount of time that they're working. But then again, the more control and direction you have over that contractor's work, that's one of the prongs of the independent contractor test, that the more direction and control you have over someone's work, the more likely it is that they're your employee. An independent contractor is really someone who has their own independent trade or service that they're just offering out to several different businesses, not just your business. So that's why it can depend. But if it's someone who really shares a role much more like some of your other employees, then you do want to be tracking their time closely, and you might want to reassess whether or not you should be classifying them as an employee or independent contractor. And Luke, do you have anything you want to add on that?
I don't have anything to add on that point. One question that I was thinking of was with respect to overtime and approving overtime. Is that something that you would typically, in advance approve of overtime like per week, or like what is kind of the recommended allotment for, at what intervals should we be approving overtime in advance?
So that probably depends a lot on your particular business. For instance, some businesses know during certain seasons, whether it's a particular month or a particular during a given month, are going to be busier than others. And if you only have a certain number of employees, sometimes employers basically are requiring overtime for those periods because they know it's their busy season and they're just going to need their employees to pull a lot of hours. In other situations, having a rule like that requiring manager approval in advance is good because at that point, if the employee is following your policy, they're always tipping off management before they're working those overtime hours. So before you're incurring those obligations to pay overtime. So in terms of the amount, I'd say it can depend a lot just based on the nature of your business, but you're in a better position as an employer to at least know that the overtime is happening before it happens and before you have to pay for it by having employees come to you first if there's overtime required. In a lot of situations, your manager might be very aware of exactly what's going on in that employee's department and know and be approving in advance the need for overtime based on certain projects or certain tasks specific to their job.
Awesome.
Does that make sense?
Yeah. Awesome. Thank you.
No problem. So now on to expense reimbursement. So this is particularly nuanced because Massachusetts law does not expressly require work from home expenses to be reimbursed, but employers, that doesn't get you out of the woods quite yet because certain travel expenses that employees incur do have to be reimbursed. For instance, if an employee is working remotely and not reporting to your workplace, but part of their job involves during the day traveling to multiple customers or vendors, then, beyond paying for travel time, you are also on the hook to reimburse those employees' travel expenses. Specifically excluded from that, though, is their regular commuting expenses. So for employers who still have a fixed site location and their employees traveling to and from that office location every day, those are regular commuting expenses that do not have to be reimbursed. But other eligible travel expenses do need to be reimbursed for an employee. And while Massachusetts law doesn't expressly say, hey, employers, you have to pay for all work from home related expenses, it does say that employers are very limited in terms of what kind of deductions they can make from an employee's wages. And especially when an employee is spending money on things that are really for the primary benefit of the employer, if those costs are reducing the employee's wages below minimum wage, that is prohibited. So you can't sort of make an employee incur expenses for your business to the point that it takes them below minimum wage. So there's still that floor. Under both Massachusetts and federal law, you can't have the employee go below minimum wage because they're taking on some of these expenses. So to the extent that the expenses may be doing that, then you would be required to reimburse them as an employer. In general, it's a good practice for employers to provide employees with or reimburse them for materials that are required to work from home, especially because in a lot of situations, employers may be in a better position to control the cost of the materials if they're the ones providing them, or specifically, buying materials in bulk. We're all dealing with, in working from home, not necessarily having access to the materials we had access to in the office, whether it's pens, papers, staples, staplers, printers, all of those typical office supplies. An employer might be in a better position to be proactive and sort of take the lead on reimbursement or provide the items directly to the employee, because maybe pricing wise, it might work out cheaper for you than if you just let the employee go out and buy whichever printer they want to get and then reimbursing for that. So it's always a good idea to have an expense reimbursement policy in place. And especially for people who've been working remotely throughout this coronavirus pandemic, an expense reimbursement policy that is tailored to working from home expenses too, and addressing, what is covered and what isn't covered, is a helpful way to sort of reduce risks by not reimbursing expenses sufficiently. And keep in mind that these expense reimbursement laws, they do vary from state to state. For instance, California requires reimbursement of just about all business related expenses. So again, and we'll get into choice of law issues in a little bit, but it's something you always want to keep in mind is where is your business, but also where is your employee now that they're working remotely, or where have they been if they've been working remotely for a while? Because it might not just be Massachusetts law, if you're a Massachusetts business, that applies if an employee's state where they're working has a more favorable law for them. So you just always want to be aware of those risks that come about a lot more when you're dealing with remote work, because some employers who are always located in one state now have employees all over the country or world, and you just want to make sure you're complying with all of the regulations and rules guiding expense reimbursement and all employment laws relating to your employees for that. So definitely employers, be vigilant when it comes to analyzing the types of resources, supplies, and costs that your employees might be incurring as a result of working from home. You can also consider reimbursing costs that an employee might otherwise be incurring, but is now using more of. For instance, a lot of people who've started working from home, employers might consider reimbursing things like home electricity or personal cell phones, simple office supplies if employees are buying those themselves, like printer paper, pens, pencils. And those are reimbursement obligations an employer might not have been thinking about before COVID if you weren't dealing with remote work at all. So it's always key to try and determine what's reasonable. For instance, it might not be the entire employee's cell phone bill, their personal phone that you're going to reimburse. Just trying to assess things on a case-by-case basis, and definitely keep records of reimbursements and try to keep records of the reason why you reimbursed what you did. If you're breaking it down by percentage, if there's some logic to that, because you want to definitely, with all employment policies, make sure you're applying them fair and consistently. That helps prevent discrimination claims down the line. For instance, if Bob gets reimbursed at 80% and then Kelly gets reimbursed at 50%, she might say, oh, it's because I'm a woman, I was reimbursed less. So you just want to know if you're treating people differently under the policy, why you're doing that, and have a rationale for it, and make sure that rationale is not based on any sort of discriminatory or legally prohibited reason.
And I would say the other argument for documenting your reimbursements and the justifications for it are also tax consequences, because in the arts and culture sector, we know that many employees wear multiple hats. In addition to being a W-2 employee here, they might also be running their own private practice or doing their own professional arts practice as a independent consultant or independent contractor, or even have their own business. So you also want to make sure that you're keeping track of this so that you're very clear as to, what are the expenses that you are reimbursing, and making sure that, the employees aren't also mistakenly claiming these on their personal income taxes or on their business income taxes as a deductible business expense. So you'll find that a lot of the conversations we're going to have here are also going to touch on either other areas of law or other business considerations. So this is an expansive piece, but it is one piece of the puzzle. All of these decisions are going to have tax consequences. They're all going to have liability and insurance consequences as well. So think about the people you need, the professional support that you need to help you kind of make decisions, and think about all of these from, a holistic perspective as well.
Absolutely. That's a fantastic point, and thank you for pointing that out. Definitely good to always be considering everything triggers something else. So always be considering everything. And so now choice of law, we've touched on this a little, but just employers always be aware that many states have their own laws, whether it's regarding employee pay, reimbursement, break time, leave, sick time, more. You always want to make sure that you know what the obligations are for employees you have that are working remotely in other states that aren't yours, so that you can determine which state's rules must apply. And so you can end up with, now that you have a largely remote working environment, with, for the first time, now you might be facing legal issues across a variety of states that you've never really looked into those laws before. So because it can be a very specific analysis of each state's law, you know, call your counsel, talk to HR. Sometimes your payroll company knows how different things need to be maintained in different states. But generally, you want to aim to comply with the most employee friendly or employee protective laws in order to mitigate the risks to you. So it's always something to keep in mind. Next, we'll turn to accommodations. So employees with disabilities or sincerely held religious beliefs may request reasonable accommodations. You may be somewhat familiar with this. Hopefully you have a process in place for handling accommodations generally. One thing to keep in mind is a request for accommodation could include a request to work from home. So say you don't presently have a remote working environment, but now you're dealing with an employee who has requested an accommodation to work from home. That's something you might need to consider and assess. In particular, to assess that kind of request, you need to engage in what they call an interactive process. So it's basically an informal process by which you as the employer clarify what an individual's limitations are and determine whether there's some sort of reasonable accommodation that allows the employee to do the essential functions of their job successfully without causing you as the employer an undue hardship. So it's very important to engage in that process. Failure to do so can definitely lead to some legal liability for the employer. And in the remote work context, it's important to recognize that even if you have a specific remote work policy in place that allows certain employees to be eligible for working from home, the accommodation process itself might be an exception to that policy. So for instance, if your policy presently requires that an employee can work from home once they've worked for the company for a year, and an employee requests an accommodation to work from home based on physical disability after only working for the company for 3 months, if that accommodation is reasonable and is not going to cause the employer an undue hardship, then you might need to let the employee work from home, even though it's earlier than you had allowed as set forth in your work from home policy. So the accommodation process can always sort of be an exception to certain rules that you might have already had in place, especially when it comes to work from home. Now, I've used the term undue hardship. If an accommodation poses an undue hardship, an employer doesn't need to provide it. That usually means it creates a large expense or in some other way is a very big burden on the employer to take on. But it's important when assessing that undue hardship and assessing whether an accommodation is reasonable for your business, that you're really engaging in an individualized assessment and engaging in an interaction with the employee about that process. Now, the employee doesn't necessarily get the accommodation that they request. They're just entitled to a reasonable one. So it could be that an employee suggested an unreasonable accommodation, or it could be that you can't give the employee the accommodation that they requested, but you can give them a different accommodation, which would also allow them to perform their job. So it's just an important piece to always keep in mind with remote work, especially if you're making a remote work policy. You're very organized, you have it all laid out beautifully, you've gone through what makes someone eligible to work from home. There still might be exceptions, so you just always want to be aware of how your policies might need to shift and make room for exceptions if an employee is asking for an accommodation. So workplace safety. It shouldn't be any surprise to you employers that you need to provide a safe working environment, but this does include remote workers. Most states require employers to provide workers' compensation coverage to their employees, and that includes those who are working remotely. So for those reasons, you want to make sure you're very clearly defining remote workers' normal hours and duties. And it's especially important to establish guidelines for what a home office or remote workspace should look like if it's something you're signing off on and saying is a safe working environment. Now that might entail keeping a designated work area, providing some sort of training on workstation setup and safety measures like ergonomics and making sure the employee is comfortable and can do their work safely, and keep your data secure, which we'll get into shortly. And you just want to make sure that you're reducing to the extent possible the employee's chances of injury, because you do still need to provide them a safe working environment even when they're working remotely. And now on to data security. So employers have a tendency to collect a significant amount of information from individuals just in the course of managing their human resource function. I mean, that can include things like social security numbers, contact information, medical information, financial information, insurance information, information derived from background checks, personnel information, and family member information. Now, regardless of whether an individual is a full-time employee, job applicant, intern, independent contractor, or volunteer, employers still have a duty to take precautions to protect those individuals' personal data and can face risk if that data is compromised. So employers should be mindful of those legal issues and how that affects how employers are processing, handling, and storing this kind of personal data. So particularly, some of the risks that employers should be aware of are cyber attacks. That can be phishing schemes or some sort of malicious insider activity, theft of this kind of data, employee negligence, error, or misconduct that leads to the sharing or breach of that data. And there's various data breach notification laws across the country that can apply, and there's also federal laws regarding data breach notification. Now, the costs associated once there is with a data breach in terms of notifying the affected individuals, providing remediation services, potentially having to pay fines, that can have a really significant impact on a company. So you really want to avoid data breach to the extent you can. And the last thing you want to do is face lawsuits from the employees or individuals whose information has been compromised and deal with any reputational damage for the public now knowing that your company has had a data breach. So no system is perfect, of course, but there are some ways to mitigate the risks by instituting different safeguards to protect your personal data. So you can conduct regular risk assessments and address weaknesses in your information security system. You can try, especially if you're dealing with remote workers, tracking users electronically by assigning them either unique names or ID numbers or access codes, implementing multi-factor authentication to make sure that the user really is who they say they are, limiting user access to electronic data based on need. For instance, every employee might not need access to all of your employee data. Depending on what their job position is, that might influence how much data they have access to. And limiting that access based on need is a better way to protect yourself from a data breach. Also, encrypting files that contain personal information can be a great way to protect it. When you're dealing with a fixed work site and not remote, physical limitations can also help data access, whether it's needing security badges, keeping visitor logs, using photo IDs to confirm identity, locked doors, cabinets, surveillance cameras. There's lots of different ways to protect both your physical data and your electronically stored information. Next, employee privacy also comes up in interesting ways in this remote work context. You may have seen that there's lots of employers that are remotely monitoring their employees more and more to try and track employee time and activity. So workplace monitoring is subject to a variety of federal and state laws regarding when employees have a right to privacy and what notice, if any, they should receive regarding remote monitoring. And sometimes for employers, the best tactic might be to disclose to employees that you are using surveillance technologies and telling them what that is, because in terms of employee privacy, that can help protect against a claim from an employee who says they had a reasonable expectation of privacy in certain equipment. For instance, employees who are using their work computers for personal business, an employee is going to have more trouble proving that they had a right to privacy in what they did on a work-based computer compared to what they might do on their personal computer. But those lines can get blurred very quickly. So to the extent that you as an employer are monitoring your employees, the best advice tends to be let them know how you're monitoring them on their work equipment so that they are aware and can't later say that their privacy was violated or invaded. So employees working remotely can also take steps to protect the privacy of their personal information, which to some extent employers might want to encourage them to do. I mean, by telling them what they should and shouldn't be doing on their workplace computers, then employers are avoiding issues of inadvertently obtaining employee private information. Employees might want to determine whether or not your employer requires you to participate in video conferences and think about what information as an employee you might be inadvertently sharing just by logging onto a Zoom call like this, what your employer might see in your background. Employees should keep their personal and work data and communications as separate as much as possible if they want to keep those communications private. The more blurring there is between work equipment and personal data from the employee, the more likely an employer has a right to access that data. So employees consider using different passwords for work and personal accounts, not downloading sensitive personal information on your work computer, or if you do, not thinking that it's necessarily private to you anymore. So those are just some employee privacy considerations that now that you're not in the office anymore, you're working remotely, there are still certain things you might be sharing with your employer. And if you're doing so, you should at least be doing it intentionally, not inadvertently. So now we're going to turn to some key legal considerations when it comes to COVID-19 vaccines, now that we've discussed some of the key legal considerations just to keep in mind with a remote workforce. So we'll cover the do's and don'ts of vaccinating your employees and whether or not you should even be thinking about this, because this is definitely something at the forefront of a lot of employers' minds right now. So first, we'll start with the obvious question. Why are we even talking about vaccines in the workplace? We can talk about what the benefits are to your business. So we know that the vaccine might have the effect of keeping your workforce healthy by preventing your employees from getting COVID, can reduce absence due to illness relating to COVID, reduce time missed from work to get vaccinated if you're looking to provide vaccinations on site, as some employers have chosen to do. It could also improve productivity and morale if more and more people in the workforce are getting vaccinated. Now, the real question of the hour that you've probably all been thinking about is, can employers mandate the COVID vaccine? Unfortunately, there's not exactly an easy answer because there are some risks as well as some unknowns, which we'll discuss today. But one thing I want employers to really be thinking about today as we discuss some of these risks is, even if you can mandate it, should you? And that's a consideration you can make for your business, just based on some of the guidance once you have the realm of different legal considerations to be keeping in mind. So we're going to cover these key considerations today, give you some background on what vaccine mandates have looked like in other contexts, what this emergency use authorization means, which is the current status of the 3 presently available COVID-19 vaccines, how accommodations come into play with vaccines, particular liability concerns that you might be thinking about as you're determining whether or not to mandate the COVID vaccine for your workplace, and some alternatives to mandating. So you might have seen there's been a good deal of back and forth on what the short answer is to, can employers mandate the vaccine? Some particularly helpful factors to keep in mind might be, what's your industry? You want to think about what your business is. How closely together are your employees working? If all your employees are working remotely and you see that happening for the foreseeable future and we want to continue that, maybe the need isn't as pressing as it might be for employees who have to report to a fixed site and work closely together. How much exposure do you think your employees are going to have to customers and other members of the public to the extent that you feel you might be liable if there is some sort of spread? And what's the need for vaccination and how justifiable is it, particularly for your business? So we're not presently seeing states themselves choose to mandate the COVID-19 vaccine. And I think even just as recently as this week, Governor Baker recently came out against even mandating the COVID-19 vaccine for public employees in the state. So because we're not seeing the federal government or the states come out and mandate it, that's why this is sort of falling to employers, and employers are contemplating stepping in here. So pre-pandemic, private employers could feel pretty comfortable requiring a lot of things of their employees, including submitting to vaccines that prevent other workers as well as customers from getting sick. For instance, flu vaccines for healthcare workers, subject to certain exceptions such as accommodations based on disabilities or sincerely held religious beliefs, have been in place for a while. We've seen mandates for students to get vaccines also in place for a while. Typically, we've seen employers in sectors that the employees themselves face the greatest risk, or the employees are working with populations that are very vulnerable if they do get sick, such as hospital workers, healthcare workers, and people who are in long-term care facilities. Those employers have often required their staff to be vaccinated against the flu every year. So we've seen a history of employers being able to mandate vaccines generally in the past, but there's something different about these COVID vaccines that makes some employers a little hesitant to do so now. And that's this emergency use authorization. So the presently approved COVID-19 vaccines have been approved by the Food and Drug Administration, or FDA, under this EUA status. So a vaccine that's approved for emergency use differs from a vaccine traditionally licensed by the FDA in a non-emergency use context. The EUA status is not intended to replace the process of traditional FDA licensure, and it's basically because the clinical trials required by the FDA to ultimately decide whether or not to approve a vaccine or not are designed to last for a significant period of time so they can collect enough data and establish whether or not the vaccines are safe and effective enough for the FDA to license. In contrast, the abbreviated timelines for an EUA approved vaccine means that the FDA just might not know as much about the vaccines, even though it knows enough to authorize them for emergency use. And the EUA is just a relatively new vehicle. It came about around 2003. So we haven't really encountered this issue too much before. So that's what's making it still unclear to employers whether or not they can mandate the COVID-19 vaccines presently, because they've only received this emergency use approval. It doesn't necessarily mean employers can't, it just presents some novel legal questions and considerations that employers need to think about, because it's not necessarily as straightforward as past vaccination mandates have been. So one of the caveats that comes with an emergency use approval is that the FDA statute requires that employees have the option to accept or refuse the vaccine, and they need to be told about the consequences of refusing the vaccine. So there's an argument to be made that employers can't mandate that employees get the vaccine if the FDA hasn't completely approved the product through formal licensure. And also, even if employers do require a vaccination for employees, the employees are specifically going to be informed by the FDA that they can decline it. So it might just be sending a slight mixed message to the employee who's being told they can decline it, but being told by an employer that they need to get it in order to work. So it would be wonderful for a federal or state agency to really come out clearly and address this. We're still waiting for that to happen. Most of them have sort of punted to each other, and hopefully we'll be getting some further guidance on this soon. or it will become a moot point. I think earlier this week, Pfizer, for instance, announced that it does intend by, I believe, the end of the month to seek full FDA licensure. So once the vaccines get full approval, this EUA sort of complication gets removed out of the equation. It's just that right now, the EUA hasn't really been tested in terms of lawsuits. There are lawsuits that have been filed against employers who mandated the COVID vaccine, and we're still sort of watching those for further guidance to see whether or not this emergency use status does change whether or not employers can more freely mandate the COVID-19 vaccine. So it's definitely something to keep in mind as just a potential unknown in terms of risk when choosing to mandate the vaccine. And so accommodations in this context, we've talked about accommodations briefly already in terms of accommodations for disabilities and for sincerely held religious beliefs. Even if you decide to mandate the vaccine for your employees, you're still required to make these accommodation exceptions, just like we discussed before with in the context of remote work. So in December 2020, the Equal Employment Opportunity Commission, or EEOC, they issued some guidance setting forth that employers may be required to make exceptions to a mandatory vaccination policy if an employee is requested an accommodation based on these grounds. So you want to be aware of these accommodation requests and that you might need to alter your approach to mandating the vaccine for those employees. So in terms of accommodations for individuals with disabilities, employers are able to exclude an employee from the workplace who poses a direct threat to the health or safety of individuals in the workplace. But in order to exclude such an employee from the workplace, an employer has to show that that direct threat poses some sort of significant risk of substantial harm to the health or safety of the individual or others that can't be eliminated by a reasonable accommodation. So what the EEOC has said is that in the COVID-19 context, if an employer is concluding that an employee is a direct threat to the workplace, they still need to be accommodated in the same process. What that accommodation might look like could be remote work. For instance, if an employee cannot get the vaccine and there's substantial risk and you've mandated the vaccine for your employees, then remote work might be a reasonable accommodation to consider for that employee who is not able to get to the vaccine due to a disability. Determining whether or not you can exclude an individual from the workplace, though, does involve an individualized assessment of these 4 factors. You have to look at the duration of the risk, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of potential harm. So where an employee does pose a direct threat, an employer should determine whether there's some reasonable accommodation available that doesn't pose an undue hardship with them. It could be remote work, it could be an altered or modified work schedule, or an altered or modified workspace, or continuing other personal protective equipment use, that there might be some sort of accommodation in place, and you need to assess whether or not that's reasonable through the interactive process when an employee has raised an accommodation issue in response to a vaccine mandate. Similarly, when dealing with employees who've requested accommodations based upon a sincerely held religious belief, once an employer knows of that belief, they need to engage in that interactive process and determine if there is a reasonable accommodation that doesn't impose any undue hardship on the employer. The religious practice or belief is specifically defined as a moral or ethical belief as to what's right and which is sincerely held. It does not matter if you're not aware of a religious group that espouses that belief or aware of whether a religious group that the individual says they belong to might not accept that belief. Really, employers don't want to go down the path of really investigating and trying to dig too far into whether or not an employee has a sincerely held religious belief. You don't get the opportunity to sort of dig in and judge the religion or judge if you've never heard of the religion or what their request is. You really want to try and take the employee's sincerely held religious belief and engage in that interactive process to determine whether or not there's an accommodation that could allow them to perform the essential functions of their job. So now that we've discussed accommodations, there's a variety of other factors to also consider if you're trying to decide whether or not you should mandate the vaccine in your workplace. And so different liability concerns. In terms of workplace safety or workers' compensation claims, if you're mandating the vaccine, an employee might have a workers' compensation claim if they have potential side effects from the vaccine that they got because it was mandated by their employer. There could also be issues if the employee is a member of a union in your workplace. You might not just be able to mandate the vaccine. That might more likely be something to bargain for with the union. Also, again, just keep in mind if it makes sense and is justifiable for your industry, for instance, in healthcare, schools, elder care, those are industries much more likely to directly benefit from vaccinating the workplace. If you're dealing with employees who are all working remotely and going to continue doing so, it might not make as much sense for your business. Vaccine availability, it's been on the increase lately, but you do want to make sure you're not putting into place any vaccination policy requiring all employees to be vaccinated by X date if they don't have an opportunity to get the vaccine in that time. And then lastly, the thing to consider is employee buy-in. So have a sense of what employee morale is in your workplace and whether or not you're going to be able to get employees on board if you're mandating the vaccine, as opposed to considering some alternative ways to encourage employees to get the vaccine. And so now that we've discussed some of the key legal and practical risks posed by mandating the vaccine, each employer will need to really weigh those risks and figure out whether on balance the risks outweigh or don't outweigh the potential benefits of a mandatory vaccination policy. So before deciding which way you want to go, if you want to go either way, you can always keep in mind that there is an option to encourage vaccination rather than require it. And there's lots of different ways to do that. It can involve offering to cover costs associated with getting the vaccine, whether that's paid time off or some other benefit, implementing education programs about the vaccine if you feel that your employees are concerned that it's not safe or not something they're interested in doing. Perhaps more education might help in your efforts to get more employees vaccinated. And in addition, providing some sort of incentive to employees who get vaccinated, which could be, for instance, a gift card or something like that, that encourages employees to get vaccinated but doesn't make it mandatory. And in terms of where we can get more guidance, we're always looking for more guidance on this topic so that we can give you more specific answers and clarity in terms of whether or not mandating the vaccine is the way to go with your workforce. Different places to look: CDC, OSHA, EEOC, the Massachusetts Department of Public Health, and local guidance. We could see upcoming guidance from any of those agencies that might say a little more one way or another whether or not mandating the vaccine is something employers will be able to do, and then removing some of the risk of the unknowns about whether or not you should. Do we have any questions?
Yeah, we do. We have, so we got a question that, suppose you don't necessarily want to mandate, but you do want to get a sense of the overall risk. Is it okay to ask your employees if they've been vaccinated yet? And I think that's a good question also in light of, we spoke last time we spoke about kind of employment law basics, like certain things you can and you can't ask of your employees really in any context, be it, the initial interview and during the course of their work. So does this fall in one of those categories that's like, too personal or something else?
So actually the EEOC has given us some guidance on that, thankfully, always good. So you can ask if an employee intends to get the vaccine. What you don't want to ask is the sort of very natural feeling follow-up question of why, because once you ask why, you might be eliciting disability-related information. And that just escalates your question to a disability-related inquiry, which has just different standards about how justifiable your questions need to be. So it is okay to ask your workforce if they're interested in and or intend to get a vaccine. That's the EEOC has specifically said that does not count as a disability-related inquiry, but be careful how you follow up with that, because once you start getting into the why, you might be getting some disability-related information that you maybe weren't even looking for, but now that you have it and you've been inquiring into the disability, then it just changes your standards in terms of what you can and can't ask.
Okay. And another question, a lot of times, sometimes these issues bubble to the surface because another employee has raised it with an employer. So is there any, and I know that we don't really have any guidance on it in the COVID-19 context yet, because we're still kind of waiting to see what any of the judiciary has to say about it, but have there ever been, is there any history or precedent we have for an employee still in a similar maybe public health context saying, well, but your failure to mandate this type of protocol or this public health program is preventing you from creating a safe work environment, which is one of the things that I'm entitled to as an employee.
Yeah, and that's definitely one of the things that's causing some employers to feel this sort of that their hand is being forced in terms of because OSHA does have a general duty clause, so employers do have an obligation to keep the workplace safe. And so employees might have some sort of argument that failure to mandate is not keeping them safe. That's when I think encouraging and just trying to recommend employees get vaccinated and incentivizing them to do so might be the best way to minimize risk from both sides. Because if you're mandating and there are several employees who don't want the vaccine, but maybe don't fall within one of the accommodation exceptions, you might be seeing lawsuits in terms of invasion of their right to privacy or some form of, violating what this emergency use authorization actually stands for. So the sort of safest path right now seems to be encouraging employees to get vaccinated, hoping to, get your workforce towards herd immunity and some level of safety that way, versus mandating it, which has some risks, or not doing anything, which also might have some risks of employees saying that the workplace isn't safe. And then when employees raise different workplace safety concerns, always all of this communication is essential. Flexibility is encouraged, not just by me, by the EEOC encourages flexibility when considering these kinds of issues. The more sort of open dialogue you can have with employees, probably the better way to avoid litigation from them down the line. Number one, that probably goes across the board with employment law, but definitely when trying to navigate these issues that a lot of people have very strong feelings about, trying to figure out the best way to balance the risks while keeping your workplace safe and continuing in a way that you feel safe, whether that's by providing accommodations to employees who just don't want to get the vaccine in terms of offering them some sort of remote working opportunities until and unless something changes and you feel that it's safer to bring them back to the workplace. But you just want to be very careful about how you start treating employees differently based on their vaccination status, especially as some employees, based on sincerely held religious beliefs and disabilities, are entitled to accommodations for those. So you might already be making some exceptions, and so you just want to be aware of how you're handling things consistently.
Okay. Sorry. We did get a follow-up question. And I think this will go beyond really the scope of employer and employee. It seems to go more into, public health regulations and kind of managing space. But what about highly encouraging vaccines for program participants? And I'm guessing by program participants, the asker means kind of outside third parties who are not necessarily, visitors, guests, et cetera, who are not employees of our organization. Can we do this? We're thinking of doing this, that doing this will help make the case that we are doing everything possible to keep our workplace safe.
Yeah, I mean, I think it's on the minds of a lot of businesses, especially businesses that interact with the public more regularly, different forums. So I think it's definitely something a lot of businesses are thinking about. The way you do it probably has to do with how your business contracts with the vendors that they're dealing with in those situations. Is this now a term and condition you're going to be putting in your contracts in order to do business with those vendors? Or is it something that's going to remain optional? How you approach that can come with its own risks, I'm sure, in terms of maybe certain vendors will not be interested in the contract if it's in additional terms or not, or maybe it's something that can be more easily negotiated. Maintaining certain safety practices, make sure you're up to date with most current CDC guidelines, Massachusetts guidelines, local guidelines, because lots of different cities in Massachusetts are handling safety protocols differently still too. So it's definitely something to be thinking about and to be considering. It's probably a business call more of how you implement that. You want to create a safe space for your employees, and just making sure that you're doing that to the best extent possible by following all of the different local, federal, state guidance helps prove that you're doing that.
Awesome. Thank you. And we did get one more question, less a specific type of, a legal question, but more, recommendations for practical strategies, where I think will be a good segue. Going forward, for those of us who are in smaller nonprofits who don't necessarily have a dedicated human resources department, is there any type of HR consortium that nonprofits can tap into to get this type of guidance from, a specialist, similar to something like a VLA or, a volunteer tax professionals for the arts as well? And that one is, I think, because there are different types of professionals to do different types of things, like, to the extent that there are, attorneys like, Danielle who do this stuff on a pro bono basis, or who have done, attorneys who do practice pro bono, like that is available. But there's also, I generally say this is more something that you should be building into your organizational budget, kind of like, again, a CPA, an insurance person. Like, there are some industries where it's just not really the custom, unlike kind of the legal profession, the custom of doing pro bono, where it really is, you do need to build it into part of your business budget of, especially if you are hiring and you're bringing on employees, you do have to think about the obligations and the cost that it's going to have. Do you need to consult with professional advisors? And similarly with risk management and insurance and accounting, all of us who are nonprofits are familiar with all of the pretty intense accounting and auditing we have to deal with and prepare for. It really is something that you should be building into your program budget. But also, I mean, yeah, there are human resources attorneys who do this stuff pro bono. Like, we can certainly see if we can do a referral for you at the Volunteer Lawyers for the Arts. But it is, if you do really need that kind of more holistic human resources guidance with coming up with programs and things like this to help with that, that might be, depending on where you are and the size of your organization, you may start needing to think about, do we need to bring on even a a consultant, an HR consultant from the outside who can help with that. But I don't know if you also have recommendations, Danielle, if you work with HR consultants who do this type of work for either nonprofits or on a modest fee basis.
Yeah, no, I mean, I completely agree with everything you said. It's definitely something you want to be thinking about because there's so many rules, and as your business grows, you're going to encounter more and more. And I think, especially when you're starting out and you're a smaller business, it's hard to try and take on those budgetary costs because there's so many other things you want to do and expand with, but you really want to be taking it on so that you're not sort of facing a couple years down the line your first lawsuit more unprepared, and now you wish you had a lot more policies in place or something down the line. So I think it's definitely very important. I think VLE is a great resource, and just trying to look up different resources, but also budgeting. I know a lot of law firms do, a lot of employment law firms do sort of a decent amount of HR work in terms of coming up with policies and things like that. I mean, I know our firm, we work with a lot of nonprofits, and we just try to tailor our rates according to what works for our clients. And I know a lot of law firms do that. And there's also a lot of pro bono attorney opportunities out there, and attorneys looking to work with nonprofits. So I think there's lots of options out there, and just making sure you're giving it the time and attention it deserves. It's one of those things you can put off, and sometimes it's only when it really comes back to bite you think, oh wow, I wish I would have gotten to this sooner, because then I wouldn't have to be spending all of this time and money talking to attorneys now.
Awesome.
So now we'll just address some overarching working from home best practices. First step, I'd say create a work from home policy. If this is something you already have in place, great. It might be something you want to reassess. If it's something you're contemplating, definitely have a policy in place. Here are some key points that the policy can address. It doesn't necessarily have to be exhaustive, and you want to always make sure the policy is tailored specifically to your business, so it's something you're actually going to follow. You don't want to ever have something in a policy that's not something you do, because then you might be held to it later. So you just want to be very clear about what you're putting in writing and making sure that it's actually the way things are happening in the day-to-day. So eligibility, we talked about briefly earlier. Work from home does not necessarily have to be a right. It can be viewed as a privilege depending on how your business is handling it. So whether you want there to be certain length of service requirements, minimum performance metrics that an employee has to meet before they're eligible to work from home, are all things to consider. But also keep in mind, as we discussed earlier, an accommodation request based on disability or religious belief could bypass some of those eligibility conditions. So those might not be set in stone. So that's just something to keep in mind if you do very closely follow your policy, that there still could be exceptions, whether or not they're written specifically into your policy based on accommodation laws. A home workplace inspection. This is something you might think about if you want to ensure that the workplace is safe, to ensure that the employees have a private and secure area where they're going to be doing their work, to the extent you're still trying to make sure you're protecting your personal and private data. But you also, at the same time, want to limit any sort of inspection to what is really necessary for your business, because you can also start getting into employee privacy issues. So just trying to tailor exactly what you're going to require and not require from employees working from home. If you want to implement any sort of trial period, if you're worried about an employee's ability to successfully work from home, this might be a good option to let the employee try it out, see how it's going. It doesn't necessarily mean if you let someone work from home that they're doing it forever. So this sort of builds in some time to make sure that it's working both for the employee and for your business. Performance management, making sure that even though the employee may have gone from seeing their supervisor every day to now working remotely, there's still a way for the supervisor to be able to supervise and manage that employee and check in regarding how they're performing and how they're doing. Have a plan in terms of equipment and technology. I mean, expense reimbursement folds into that as well. Know that the requirements can vary from state to state, in terms of what you need to provide and what the employee should be providing, and be wary of any plans as the employer to unilaterally deduct from an employee's wages. You don't want to go below minimum wage, and Massachusetts law in particular is pretty strict about when you're not allowed to make deductions from employee wages. So be careful about trying to do that for equipment and technology without looking into it first. On expense reimbursement, it makes sense to have a written policy in place outlining expense reimbursement in general, and also for telecommuting arrangements when that's becoming a more predominant part of your workplace. Employers with employees working from multiple states might choose to have a work from home policy that's tailored to each state, or alternatively incorporate just the most generous requirements from one state into a single policy applicable to all employees. It can depend on what makes the most sense for your business and how many different policies you want to have going at once, but at the same time, you might be sort of taking on more responsibilities by incorporating the most generous requirements if you don't have to for all employees who are in different states. You may also want to address just how to deal with issues employees might face if they lose connection to your system or they're having other sorts of system issues, keeping in mind how to keep your data secure, addressing safety issues. I know we've talked already about workers' compensation coverage, making sure remote workers are covered, tracking employees' hours worked, basically being clear again about when work starts and when work stops, the same way you may have previously done, whether through punching in and out or some other system. You want to make sure you're tracking those employees' hours. You want to be aware of any related income tax obligations if the employees are working in other states that might be different from what you've been doing previously, and also ensure that employees are continuing to comply with other company policies. So after you create your work from home policy, the next thing you should do is mitigate the risks of data security breaches by creating a written information security program, also called a WISP. You might already know about these, hopefully you do, because Massachusetts law requires that anyone with personal information relating to a Massachusetts resident has one of these WISP policies in place. Basically, the purpose of them is to manage the prevention, detection, and response to information security issues. That includes responding to a data breach and making sure you're periodically testing that plan and making better solutions for how to protect your information. And in terms of how personal information is defined, it's pretty broad under Mass law. Basically, you're an individual with someone's personal information if you have a Massachusetts resident's first name and last name, or a first initial and last name in combination with their social security number or their driver's license or state issued ID card, or a financial account number. So if you have those pieces of data combined, then you have someone's personal information and you need to have one of these written information security programs in place. There's all sorts of things you want to make sure that the program contains. Basically, by developing it, you want to make sure that you're designating certain employees in your organization as responsible for the program. You want to be identifying and assessing any security risks, developing policies for how you store, access, and transport this personal information, impose disciplinary measures for anyone who's violating the policy. You want to limit access to your information when employees are terminated. You want to make sure you're overseeing practices of third-party vendors who might be getting some of the personal information that you have access to. You want to restrict access to physical records. You also want to monitor and review the scope and effectiveness of this program and edit it accordingly, and make sure you're documenting any steps you take in response to data security incidents. So this WISP program is also something that's very important and very essential. And because of the broad definitions, most employers have enough information, just even by having one employee or by engaging with one vendor, to constitute personal information under this policy. So you want to make sure that you're protecting your data and have this system in place, which will help you do so. You can always have your IT department and security, if applicable, weigh in on the best ways to do that, or if you have an IT contractor or something like that who can help make sure you're doing this in the best way for your business.
And I would just say that this is one of those things that it's really easy to make it and feel good that you have it and then never ever look at it again. Read your WISP. Maybe make it, integrated with your employee onboarding policy as well. Like, make sure this is one of the documents they're familiar with. Make sure the person who is designated as, the WISP coordinator, the information security coordinator, knows that it's their role and that everyone knows who that is. And yeah, as Daniel said, make sure that you're actually evaluating this regularly and making sure that you're reviewing it and determining, okay, is this, sufficient for our needs? And it's just one of those things where you might have to have a policy in place. You might just, again, use technology. You might just have to put a calendar, event on your business calendar, just a reminder that, okay, once a quarter, review the WISP policy. Because I think this is something that can happen pretty often with a lot of internal policies and documents like that, is that we create them. You might have come to us to have us put you with someone who can help you create it, and then you feel good, everyone's approved it, and then it might go on a shelf somewhere, a digital shelf at this point, and never get looked at. So make sure that with respect to these policies that you're creating, that you are actually taking the time to look at them and making sure that the key people who are going to be affected by these policies are also familiar with them and know who the key people are who they need to contact if there is an issue under these. Because having it isn't just enough. You have to make sure, as Daniel said, that you're actually following it. And stuff like this happens all the time where, we even see it at the organization level where we create bylaws for people and they don't follow them. Make sure you are following the policies that you're imposing.
Absolutely. Very, very good advice. So we definitely see that a lot. You can just end up pulling policies from anywhere, sometimes from your former employer, from a Google search. You just want to make sure you're following the things that you put into place. And just a couple more additional best practices to keep in mind for remote work. Accurately track all the time that's worked. Administer remote work policies in a consistent, non-discriminatory manner. Ensure your job descriptions are up to date and that they're identifying the essential functions of each position. If you had a job description that said the employee had to be in the office every day and they've been working remotely for a year, you want to consider whether or not you need to modify that, or if the employee's job has changed, or if you intend, post-pandemic to return the employee to the workplace, make sure you're just having open communication with the employee about that too. Again, workers' compensation policies, making sure that you're covering all of your remote workers and complying with all federal, state, and local obligations. And so for some employers who've embraced working from home throughout the pandemic, there's still, to some extent, an increasing desire to get back to some sort of normal and return to in-person work, whether for all of your workforce or part of your workforce. And for others, they've seen the benefits of having work from home in some positions, but maybe not others. And so they might be considering returning certain job functions to the workplace. So here are some common issues we've seen that arise when employees are being told to return to work after either working from home, going out on unemployment, and trying to be brought back by an employer. Some employees indicate that they're worried about returning, worried about their family if they return, based on different high risk factors, based on their own medical condition, based on trying to find childcare, even though some of the schools are going back a little more now and more leaning towards full time, or the employee is vaccinated but worried about being around non-vaccinated employees, or they want to return but they don't want to get vaccinated. So these are all sorts of issues we're seeing all the time, and so we should discuss how should employers go about bringing employees back to work. And so the overarching returning to work considerations are really, communication is always critical. Be flexible, try to work with your employees to develop solutions, and always be mindful of workplace safety. It's okay to be putting workplace safety in a prominent position. You want to be doing that and thinking creatively about how you do that while still complying with the different guidance at the local, state, and federal levels. So these are all things that you want to be keeping in mind when you're talking about returning to work. You want to know what the most recent guidance is so that you're complying with it. And it's unfortunately not something that's always easy to stay up to date on because it can change quite regularly. So in terms of how you can keep your workplace safe, make sure you're implementing safety protocols in accordance with all local, state, and federal guidance. In Massachusetts, you needed to have a COVID safety protocol or plan in place when you're returning to work anyway, so you might already have that in place. And just make sure you're following the guidance pertaining to your sector or industry. Massachusetts in particular has released a lot of different sector specific guidance and protocols for what returning to the workplace looks like, so make sure you're familiar with those. Screening for COVID symptoms if you don't have a workplace in which you've mandated the vaccine, and even if you do, just making sure you're complying with all screening protocols, those daily acknowledgements that you might have been seeing if you've been going into work at the work site still need to remain in place. So a key consideration to all of these things is communication and transparency. Consider drafting policies and procedures that reflect how you're going to do this. Again, because communication is key, and making sure your workforce understands what your expectations are all very helpful. And then just finally, some legal considerations when it comes to returning to work. And when approaching this task, it can be helpful to make sure your business is just thinking about all of these things in addition to all of the local and state guidance. OSHA has issued some guidance on best practices on what safety looks like. They're likely to issue more, so make sure you're staying up to date on all of that. The Americans with Disabilities Act is very critical for review if you're trying to figure out some of the questions you can and can't ask employees so that you're not getting into that medical examination or inquiry we talked about a little earlier. The Fair Labor Standards Act helps at the federal level give you a sense of what employees need to be paid for or don't need to be paid for, in addition to Massachusetts law. And just referring to leave laws as necessary, Massachusetts earned sick time law, the voluntary extension of the FCRA law, if you're in a business that has voluntarily extended that leave, then looking to those laws as well. And that brings us to the end. Are there any other questions?
Great. I think I'll just chime in real quick and say thank you to the both of you. We do have one question left, but before folks go, because I know we are right at time, I do want to mention a service of Mass Cultural Council that Luke and I have prepared for Massachusetts-based cultural nonprofits. So you do not have to be a grantee, a current grantee of Mass Cultural Council, just that you are based in Massachusetts and you're a cultural nonprofit. In addition to these webinars, we know that this kind of work is also individual. And so this is a good basis to get all of this, but your situations, as Danielle has mentioned, are completely different depending on your discipline and where you operate and what your workforce looks like and how you're interacting with the public. And so we have actually put together 30 hours of consulting, legal consulting. Thank you, Luke, for helping us with this. And this is through the VLA and the Arts and Business Council of Greater Boston. And so I just put into the chat a survey link. If you are interested in having an hour of time to talk a little bit more through some legal considerations for your organization, obviously it doesn't have to be about vaccines or the things that we talked about today. It could have been any number of things that we've talked about in this series. We'll put you, there's a few questions on an intake, and then I'll work with Luke and the VLA in order to get you someone who can help you out. This is great if you didn't want to ask a question on the webinar today, or you want to have a little bit more confidential conversation, we can help you with that. So just wanted to share that as a resource before we close today. And I think there is one last question in the queue.
Yeah, and I wanted to save it for this because I felt that that was a good kind of tee up for the additional consulting hours program that we're doing with MCC. But yeah, do you have anyone who can help create? And this was in the context of a work from home or remote work policy. Do you have someone that can help create the policy if the company doesn't currently have one? And yeah, that is one where you would come to us volunteer lawyers for the arts, and we could match you with an attorney who, if you're seeking pro bono services, or you'd reach out to someone like Danielle at Morgan Brown and Joy that also work with nonprofits on more of a modest fee basis. But yeah, that is the point where you would reach out to a employment attorney, or alternatively find a human resources consultant, oftentimes going to be an attorney or a member of a law firm, or an independent practitioner, usually most commonly. But yeah, that's the point where you reach out for help. And we know, as Michael said, this is really introducing a lot of the broad principles, and we know that it does necessitate a more individualized conversation.
Great. I don't see any other questions. And again, those of you who want to take this to the next step on the intake, feel free to access that now. And we're working through those right now. So it's very much real time. I want to say thank you so much for Danielle and Luke for providing our series. It's always a great time. This is action packed, 90 minutes. We learn a lot of stuff from you. So thank you so much for that. And also a particular shout out to Luke and Jim and your work with the Arts and Business Council of Greater Boston for these 6 webinars that we've had in this series. Hopefully this is a phenomenal resource for organizations across the Commonwealth to get a little better handle on the legal considerations of not just operating post-COVID, but maybe some of the stuff that they really should have looked at up to this point already. So with that in mind, thank you to the both of you, and I'll see everybody else on our session at the next Mass Cultural Council webinar. Take care and stay safe.
Thank you.
Thanks, Michael.
Thank
Thanks,
you.
Danielle.
Thanks.